Laura Odell. She's agent from the Michigan Department of Corrections. We're here today for a probation violation hearing. I think we're actually set for an informal, having there just been recently an arraignment. Looks like that arraignment was done back on April 30th. Mr. Hartel, what are we doing today?
Yes, Your Honor. I believe we reached a global resolution for that and the underlying pretrial as well. I shouldn't say underlying, but also the pretrial in his other cases.
Okay, hold on. Oh, that's right. So 3675 is the pretrial, and then 3663 is the probation violation.
That's correct. That's
May I approach?
Okay, thank you.
I did turn in advice of rights on Friday.
Okay, thank you very much. All right. And is there, for the probation violation, is there going to be, is it just a plea to the two that I see in the new charges?
Yes, Your Honor.
Okay, got it. So there are actually, yes, quite a few, like 13 counts, but he's going to plead guilty to 2 of them.
Well, the offer would be him pleading to no contest, Your Honor. That being said, I guess there's potential civil liability, but he also indicates that he was not necessarily in his right mind that day and does not remember everything that there is to it.
I do see that count 1 on the probation violation alleges that he failed to take medication as required at the jail for his own mental health treatment. All right, that makes sense. Mr. Hartel, is that a complete and accurate statement of the probation violation and the new charge?
It is, Your Honor.
All right. Now, I don't know which ones we want to choose. Maybe just choose counts 1 and 2 on the new case. Is that right?
That is what we
Okay.
had decided on, Your Honor, and the police report is up there and marked.
All right. So that means on the probation violation allegations, it's going to be counts 7 and 8. All right. Copy.
Yes.
Thank you. All right. Mr. Ringstrom, anything further to add before I turn to the client and the defendant?
No, Your Honor.
All right, thank you. Oh, wait, I see you guys. No, disregard. I got it. All right, Mr. Cole, have you heard what the attorneys and I have just discussed?
Yes, Your Honor.
Is that how you wish to resolve the files today?
Yes, Your Honor.
To the best that you can, please raise your right hand for me.
Yes.
Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
Thank you. We're going to take just a moment. I see some confusion over there. Maybe, maybe not.
Yeah, I didn't know if you wanted the bench warrant counts to correspond deputy wise with the.
I thought I did. We've got for counts 1 and 2, we've got Deputy Seiler and Deputy Booms. Deputy Seiler is count 8 and Deputy Booms is count 7.
The issue that we're
Thank
having, Your Honor, is that it was 3 different officers involved twice, but I think that the court would have it right.
I got it. I got it. All right. Thank you very much. I guess I could have done 5. We're just going to do 7 and 8.
Okay.
All right. Thank you. All right, Mr. Cole, you've got a couple cases going on and we're going to talk about them. Now, there's a new file and I'm going to talk about that one first. Now, in this new case, you are charged with six counts of assault, resist, obstruct a police officer. And each one of those is a felony punishable by up to 2 years and or up to $2,000. Now, what I need to know here from counsel is, did this occur within a confinement facility?
Yes, Your Honor.
Okay. And do the people intend to request consecutive sentencing even though it's within the discretion of the court?
People do not intend to request it.
Okay. Thank you. So of those 6 counts, again, if you were found guilty or pled guilty to 2 or more, or if you pled no contest, they could be sentenced consecutively. So for instance, just as an example, if I gave you 6 months on one and 6 months on the other, you'd have to serve a full year. But I'm told that the people are not requesting consecutive sentencing. And I don't intend to issue consecutive sentencing. You understand?
Yes, Your Honor.
Now, I'm told today that you're going to enter a plea of no contest to 2 of those counts. And we're going to go with count 1 and count 2. And then if you enter a plea of no contest and I accept that plea, the other counts will be dismissed. Does that make sense?
Yes, Your Honor.
All right. Now, I have here a thing called a pre-trial agreement, which was handed to me by counsel. And I'm holding it up here, and it has 2 pages. All right. Now, I see your signature, or at least it appears to be your signature on page 2. Is that your signature?
Yes, Your Honor.
Now, did you read through when this pre-trial agreement, which is only 2 pages, but did you read through it before you placed your signature on it?
Yes, Your Honor.
And did you talk to Mr. Hartel?
Yes, Your Honor.
And was he available for you and answer any questions that you had and talk to you about the evidence and police reports and things like that?
Yes, Your Honor.
And did he go over with you your options?
Yes, Your Honor.
And are you satisfied with his advice as of today?
Yes, I am, Your Honor.
Thank you. So again, I'll note here that this written pretrial agreement provided to me by the parties is consistent with the pretrial agreement as we discussed, except for I forgot one thing. There was also on the felony information a sentencing enhancement called a habitual offender second. Now, habitual offender second can increase the maximum punishment for a felony, in this instance, from up to 2 years to up to 3 years. However, that is also going to be dismissed. Do you understand that?
Yes, Your Honor.
Okay, great. I'll also note here that we have a pretrial agreement report that also appears to have signatures from the counsel party. So I'll put that over here. Now, by entering a plea of no contest, it has the same impact as a guilty plea. The difference is instead of requiring you to recite a factual basis, I'm going to look at something such as a police report to make a determination. Now, it's really important to understand that if you plead no contest and I look at this report that the parties have provided to me, you can't come back and say that anything in here is untrue. You understand that?
Yes, Your Honor.
Okay. And also, I get to accept a no contest plea in only a couple ways. And one of them is when there's a lack of memory. And that could be due to mental health issues, lack of medication, or even taking medication and being intoxicated. But again, I can take a no contest plea based upon what the counsel have told me. Do you understand that?
Yes, Your Honor.
Now, before I talk about what you're going to ask you for your plea, I need to go over certain rights. Now, if you enter a plea of no contest in this new file, you'll no longer have a trial. You'll be given up the right to be tried by a jury, the right to be tried without a jury if you chose, the court, the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have silence used against you, and the right to testify if you chose to testify. Mr. Cole, do you understand those rights?
Yes, Your Honor.
And again, even more importantly, do you understand that if you enter a plea of no contest, you will be waiving those rights as they apply to this particular case?
Yes, Your Honor.
Also, based upon the plea, any appeal will be done by filing of what's called an application for leave to appeal and not an automatic or claim to appeal by right, which is only guaranteed when someone is convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also would be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record. Mr. Cole, other than the terms of the agreement that we've gone over, have there been any other promises, threats, or inducements to force or coerce you to plead guilty that we haven't talked about today?
No, Your Honor.
Are you therefore entering the plea of your own free choice?
Yes, Your Honor.
Now, Mr. Hartel has probably talked to you about potential sentencing, maybe the sentencing guidelines, and try to give an idea as to what he thinks the court may sentence you to. The question I have, however, is, has he or anyone promised you, suggested to you, or led you to believe what an exact sentence would be?
No, Your Honor.
Now, if you enter a plea today to those counts 1 and 2, we now need to talk about the other file for which there's a probation violation. In that particular file, there are 13 counts of alleged probation violations. You were placed on probation by this court on April 7th of this year. The court takes judicial notice of the terms and conditions of probation that were signed by me on April 7th, and and apparently refused by you on April 10th, but witnessed by another agent of the court of the Sheriff's Department. Also, in that request and warrant for probation violation dated April 28th of this year, again, there were 13 counts. Now there, as we were mentioned, as you were informed earlier or previously, you have the right to challenge those 13 counts at a contested hearing and have the prosecutor prove them by a preponderance of the evidence, which is a lower standard of proof compared to that of proof beyond a reasonable doubt. You also would have the right to be represented by your attorney at that hearing, the right to question and cross-examine any witnesses presented against you, which presumably would be the same witnesses in the new file, the right to present witnesses to evidence or testimony, and the right to remain silent and not have that silence used against you. Now, if you're found guilty of, and I'm told today that you're going to plead no contest, I'm sorry, to counts 7 and 8, which have to do with the same deputies that are involved in counts 1 and 2 on the new file. Now, if you do, and the court accepts that plea, the other 11 counts will be dismissed and you'll be resentenced on your original offense. In that case, you were convicted of domestic violence as a third offense, which is a felony punishable by up to 5 years and up to $5,000 in fines plus costs. Do you understand?
Yes, Your Honor.
And again, the court would be taking a look at presumably the same exhibit to support the no contest plea in both files. Do you understand?
Yes, Your Honor.
All right. Therefore, and I'm going to remind you before I go into taking your plea, I anticipate your plea to be no contest. I'm not telling you what to say. I'm just telling you that's what I anticipate. The reason why I caution you is because I caution everybody when they do a no contest plea, because some people just blurt out the word guilty. So we don't want to do that. We want to respect your right to enter the no contest plea. In file 3675, as to counts 1 and 2 of assault resist obstructive police officer in the performance of his duties, how do you plead?
No contest, Your Honor.
Thank you. In file 3663, which is the probation violation allegations, as to counts 6 and 7, how do you plead?
No contest.
Thank you. All right, the court has received what is now marked as People's Exhibit number 1 from the prosecutor's office. It is a Missaukee County Sheriff's Incident Report 26-794-157. It consists of 5 pages. Mr. Ringstrom, are you asking the court to accept People's Exhibit number 1 for the taking of the pleas in both files and for sentencing?
I am, Your Honor.
Mr. Hartel, any objection?
None, Your Honor.
Thank you. People's Proposed Exhibit number 1 is hereby admitted. One moment. All right, the court first notes that there is a date which is consistent with the dates alleged in the probation violation and the new felony information of events occurring on or about April 21st of this year here in Missaukee County in Lake City. One moment. note specifically in People's Exhibit number 1, there is a thorough description of the events on that day. Specifically, they focus there a lot about the involvement of or acts upon Deputy Booms, who is a Missaukee County Sheriff Deputy, and the performance of his duties. And then subsequently, in the affidavit attached to the request for a complaint, there's further information discussing the involvement of Deputy Seiler, who the court notes is a deputy with the Missaukee County Sheriff's Department. The court also notes that it occurred in the Missaukee County Jail. I only make that note, even though, again, I've already said that I don't intend to find that sentencing defendant to the consecutive sentencing. Mr. Ringstrom, do you believe the interests of justice do not require the recitation of facts to support the plea?
I do, based off of the other probation violations.
Thank you. Mr. Hartel?
I also agree.
Mr. Ringstrom, do you believe that People's Exhibit number 1 supports all the factual elements required for counts 1 and 2 in the new felony information and counts 7 and 8 in the probation violation?
I do, Your Honor.
Mr. Hartel, do you agree?
I agree, Your
Mr. Ringstrom, are you aware of any other promises, threats, or inducements?
There is none, Your Honor.
And do you believe I complied with Michigan Code 6.302 and 6.445?
I do.
Mr. Ringstrom, do you agree with both?
Also agree, Your Honor.
All right, good enough. Thank you. The court agrees and finds the defendant's pleas today are made freely, knowingly, and voluntarily. The court finds specifically that the interests of justice do not require the recitation of facts. Not only could there be potential civil liability, but also based upon the other information about mental health and status at the time when the events occurred. Therefore, the defendant is found guilty in file 3675 of counts 1 and 2. The remaining counts and the enhancement will be dismissed at the time of sentencing. In file 3663, the court finds the defendant guilty of counts 7 and 8 on the request and warrant for the probation violation, and the remaining 11 counts are hereby dismissed. All right, we can probably set this for sentencing jointly together, Ms. Odell. Do you agree?
I agree, Your Honor.
Mr. Ringstrom?
I agree, Your Honor.
Mr. Hartel?
I agree and would appreciate that so that he can get as much credit as possible.
That's why I agree as well. All right, good enough. Mr. Cole, we're going to set this out for sentencing, and it'll probably be in about 4 weeks. Now, between now and then, even though you had a prior pre-sentence investigation report prepared, we're going to do an update to that and have you fill out another PSI packet. You'll be subject to another interview with Ms. Odell or someone from her office. And you have the right to have Mr. Hartel present. Also, Mr. Hartel will meet with you prior to coming back for sentencing to go over that. Each side has the right to make objections or request corrections to the report at the time of sentencing. Okay, anything else, Ms. Odell?
I don't think so, Your Honor. Thank you.
Mr. Ringstrom
Not for today, Your Honor.
and Mr. Hartel?
No,
All right, the court revokes any bond that might be out there. I don't think there is any. Remands him to the custody of the Missaukee County Jail. Is he still serving his original sentence?
Yes, Your
Yeah,
Honor.
that's what I thought. So, yeah, he's not gonna get any, well, anyways, we'll see how it all works out. Mr. Cole, I know today, I want to highlight for you, if there's any mental health treatment that you need, or they're able to provide for you, or they are providing, I strongly encourage you to participate, because we want to make sure that you are receiving any treatment that you need. Thank you, folks. We are adjourned. Mr. Ringstrom, your police report.